Nature of fundamental rights. Article 12 and 13. Fundamental rights are the rights that are found in Part 3 and Part 3 of the Constitution alone. Other rights like right to vote are outside Part 3 and hence are not termed as fundamental rights. Similarly, rights outside the Constitution like right to information too are not fundamental rights. Nature of fundamental rights. Most rights are negatively worded or are in the nature of negative injunctions against the state. Here injunctions means a formal command. Most rights with what the state is not allowed to do, like the state cannot deny freedoms, equality, while this negative nature of the rights may seem to be the norm. There are some positive injunctions. Injunctions again a formal command towards the state too, where the state is instructed to perform its duties. An example being Article 21A concerning the right to education. Most of these rights functions vertically against the state. These are the rights that functions horizontally like Article 17 concerning untouchability that prohibits practice of untouchability against fellow citizens. The vertical nature of most rights does not mean that those rights can be violated by citizens, while violation of these rights by the state can be addressed with the constitutional remedies under Article 32 and 226. Any similar violation by citizens cannot be addressed by constitutional remedies and hence have to be addressed through the usual means like civil remedies of FIR, subordinate courts, etc. They are all injusticiable and citizens can address their violation directly to the apex court or the concerned high courts. They are available to all citizens of India. In any article across Part 3 which contains the term person, it denotes that the right is available to both citizens and non-citizens. For example, Article 14, Article 19, etc. Article 14. Equality before law. The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Prohibition of discrimination on grounds of religion, race, caste, sex or place of birth. No rights can be enjoyed in absolute terms and hence have reasonable restrictions imposed on them. First, can be suspended during national emergency. Article 352. Only Parliament can modify by law, restricted or abrogated the extent of application of fundamental rights. With regard to police forces, parliamentary etc. Under Article 33 is an example of Parliament exercising this power is the Police Force Restriction of Rights Act 1966. Article 33. Power of Parliament to modify the rights conferred by this part in their application, etc. Parliament may by law determine to what extent any of the rights conferred by this part shall in their application to the member of armed forces or the member of the forces charged with the maintenance of public order or the persons employed in any bureau or other organization established by the state for purpose of intelligence or counterintelligence or persons employed in or in connection with the telecommunication system set up for the conferred means bestow, hand over something. Let me tell you one thing. Jobs in public services comes with its perk and disabilities. The telecommunication system set up for the purposes of any force, bureau or organization referred to in clause A to C be restricted or abrogated so as to ensure the proper discharge of their duties and the maintenance of a discipline among them. Most of the rights are self-executory. They are readily available and need no additional law or provision to execute this. Example of fundamental right that isn't self-executory is Article 17 concerning untouchability, which prohibits untouchability and sanctions punishment in accordance with law. Hence, this fundamental right needs a separate law to enact its provision and hence isn't self-executory compared to other fundamental rights which are self-executory. Even the Article 21A concerning right to education isn't self-executory and needs a law to execute it, namely the Right to Education Act. And even right against exploitation under Article 23 too isn't self-executory and needs a law to actualize it. The power to make these laws in order to execute the fundamental rights lies solely with the Parliament. Article 35. Article 12. Article 12 defines states in the Part 3 for the purpose of interpreting rights. Since most rights functions vertically against the state, it becomes imperative to define the state to effectively actualize these rights. Article 12 mentions state as including government and Parliament of India, the government and legislature of each state, local authorities both rural and urban, authorities within territory of India and under the control of government of India. The most debates happen around the term authorities under the control of government and the debates become vague and ambiguous. The state's function is dynamic, and there has been increasingly a pattern of government function being outsourced to authorities that function on behalf of the government. The question arises that whether citizen can claim fundamental rights against these entities too. The code has given a number of tests for these. If the body is set up by a statute or executive order, for example, LIC, RBI, etc. If the government exercises substantial financial and administrative control over it. If the entity is used as an agency of the state, instrumentally of the state. If the function performed by the agency were performed by the state before and are now being performed by the agency. More clarity. If it performs sovereign functions of the state like defense, taxation, law and order, etc. Law Commission suggested including BCCI as public authority under RTI Act. An interesting observation is that there is no explicit mention of judiciary as being part of state. Basically, judiciary is there to protect the citizens' rights, and the usual violators of rights are executive entities like police, civil servants, and legislative entities like parliament that can legislate laws violating the rights of the people. Judiciary is a dispassionate observer. Whenever the citizens' rights are violated, the judiciary restores those rights. Judiciary doesn't engage in the actual implementation of these rights, and hence there should not arise any question of violation of rights. But judiciary doesn't just perform its basic judicial functions, but also administrative functions also, like management of its own staff, laying down procedures to perform functions which may violate fundamental rights. While the judiciary is in its judicial capacity is a restorer of rights and isn't a violator and hence not under the definition of a state. The judiciary under its administrative capacity can violate the administrative rights of citizens. On this question, the court has admitted that the judicial function will not be attracted the definition of the state, but its administrative function may attract the definition of state under Article 12. Another aspect of debate picking up recently is that the courts are increasingly engaging in judicial activism. Judicial activism means policy to achieve a political or social goal. Means they are giving some policies to achieve political or social goals and performing the functions of the executive or legislature. And if these action violates the fundamental rights of the citizen, by the judiciary will attract the definition of the state under Article 12 or not. There has been no response come from the courts regarding the issue, and it is a still burning issue. Article 13 and amendability of fundamental rights. Judicial review is the power of the court to review the actions of the executive and the legislature while performing their functions if they are unconstitutional. The power of judicial review of the judiciary is not mentioned directly in the Constitution, but can be derived from the understanding that we are a liberal democracy and have a separation of the powers in the government. Since there is separation of power in the government, it is implicit that judiciary will have the powers of judicial review to strike down any unconstitutional law. But Article 13 explicitly deals with the power of the judiciary to strike down laws violative of fundamental rights, i.e., Part 3 of the Constitution, not the whole Constitution, Article 13, Clause 2. While the provision provides to declare any law violative of Part 3 as void, it does not categorically mention that it is a duty of judiciary to perform that function. The government usually doesn't take away or abrogate rights but reduces the availability of the right by amending the right itself in the Constitution. Article 13, Clause 2. The state shall not make any law which takes away, abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. Article 13, Clause 2 states that the state shall not make any law. Law is usually understood as ordinary statutory law passed by legislature. But can the constitutional amendment laws passed by the legislature to be considered law as mentioned in Article 13, Clause 2? The question whether fundamental rights are amendable or not lies in the answer to the question whether constitutional amendment law qualifies as law under Article 13, Clause 2, or basically how we define law under Article 13. A narrow interpretation of the term law includes ordinary law, and constitutional amendment is out of it, and hence consequently it leads to possibility of states violating fundamental rights through constitutional amendment laws. A wider interpretation of the term law in the Article 13 would include even the constitutional amendment laws, and hence include them under judicial review provided under Article 13 to protect fundamental rights, leading to fundamental rights being unamendable. So we have narrow interpretation and wider interpretation. Narrow interpretation only ordinary law under Article 13. Wider interpretation also include constitutional amendment under Article 13. Narrow interpretation, constitutional amendment not as law under Article 13, fundamental rights amendable. Wider interpretation, subject to judicial review, fundamental rights unamendable. The Apex Court position. Shankari Prasad case, 951 to Sajjan Singh case, 1965. The Apex Court held on to a narrow interpretation of the term law in Article 13 and considered constitutional amendment laws out of the scope of the definition. This proposal that the court made was that the parliament has the right and authority to amend the constitution and it is unfettered. Unfettered means no restraint or tied down by bonds. In Golaknath case, a 11-judge bench with a narrow margin of 6-5 reversed its earlier interpretation and moved toward the wider interpretation of the term law, and hence including even the constitutional amendment laws under the purview of judicial review. Here, purview means range of interest or activity that can be anticipated. The court observed that the fundamental rights are termed fundamental for a reason. They have been given a uniquely elevated position and status in the Constitution and hence are transcendental in nature. Transcendental means existing outside and rise above the other provisions. The court hence deemed the fundamental rights unamendable. Reaction from the executive and legislature. In the 24th Constitutional Amendment Act 1971, both Article 13 and 368 are amended. Both Article 13 and 368 were amended by adding Article 13 Clause 4 and 368 Clause 3. Article 13 Clause 4 stated that nothing in Article 13 would apply to any amendment of the Constitution done under Article 368. This was an attempt to narrow down the interpretation of the term law used in Article 13. Article 368 Clause 3 stated that nothing in Article 13 shall apply to provision made under this article to double secure the narrow interpretation. This was challenged in the future in the Keshwananda Bharti versus the State of Kerala 1973, popularly known as Keshwananda Bharti case. Keshwananda Bharti case 1973 was a case concerning freedom of religion that ultimately decided the question regarding the amendability of fundamental rights. The courts took a middle path between the narrow interpretation espoused from Shankari Prasad case, espoused means adopt or follow, from Shankari Prasad case till Sajjan Singh, and the wider interpretation in Golaknath case. The court observed that all parts of the Constitution are amendable, but no change or amendment should have the effect of changing or altering the basic structure or core identity of the Constitution. The court generally did not define the basic structure as those elements without which, or if there is an infringement of them, the Constitution will lose its very soul and essence. The Apex Court in various judgments over the last 5 decades has listed out the various features that constitute the basic feature. Some feature constituting the basic structure: supremacy of constitution, rule of law, separation of powers, judicial review, federalism, secularism, unity and integrity of the country, sovereign, democratic, republic structure, dignity of the individual, independence of judiciary, principle of welfare state, parliamentary form of government, limitation on amending powers under Article 368. Critique of basic structure, non-constitutional basis. The Constitution as a whole is a basic law, and the basic structure provision is an attempt to locate something even more basic than that. This line of thought was not there in the Constituent Assembly. The Constituent Assembly never notified that some features are more important than others. Here, line of thought means way of considering a matter. Rewriting the Constitution. The judiciary's job is to interpret the Constitution, and the courts attempt to locating a more basic law within the law itself, i.e., the Constitution practically amounts to rewriting the Constitution and assuming the role of Constituent Assembly. The Supreme Court has practically become the third and decisive legislative chamber of the Parliament apart from the Lok Sabha, Rajya Sabha in framing laws. Decisive means characterized by decision and firmness. Against the principle of majority. Democracy can be described as rule by majority. Constitutional amendments require overwhelming majority to pass in the legislature. Thus, assumption of the role of Supreme Court as a role arbiter of the validity of the constitutional amendment amounts to the illegitimate negation of democratic rule, i.e., majority rule. But judiciary in liberal democracies with separation of powers do play a counter-majoritarian rule, thus preventing arbitrary laws and laws violative of rights from coming into fruition. Fruition means something that is made real or concrete. A lawmaking process based solely on majority rule, where neither the opposition, media, nor public opinion can halt the passage of arbitrary legislation, then it becomes imperative for the court to come into the picture and play a counter-majoritarian rule. So this criticism has a significant caveat attached to it. Decision by narrow margin. This 13-judge bench had a very narrow majority of 7 to 6, and thus such a fundamental revision of the Constitution with such a slim margin inspires less confidence. Decision to include or exclude features based on subjective assessment. The power to decide the inclusion of subjects in the basic structure lies with the apex court bench and the judges on it. Hence, any subject's inclusion or non-inclusion is based on subjective assessment of the judges, which can vary from person to person and even time. Points in support of basic structure. In democracy based on constitutionalism, the concept of constitutionalism abhors absolutism. There is no place for absolute power in a constitutional democracy. Hence, Parliament's power to amend the Constitution cannot be absolute and have to be subjected to some limitations. Basic structure doctrine helps in preserving our core value and constitutional identity. Popular opinion is always fleeting and always fluid. If there is some provision that the country wants today, it may not want tomorrow. The Parliament can amend the Constitution but cannot redraft it. Temporary urges of the majority of today cannot be made to override the permanent vision in the Constitution of our farmers. The Parliament thus has the power to amend and not redraft the Constitution. Basic structure privileges uncertain democracy over certain tyranny. The overarching framework of our Constitution is secular, liberal democracy. Thus, the elements in the Constitution works toward enacting this framework. Any provision being classified as a part of basic structure actually works toward the further strengthening of the goal toward secular, liberal democracy. But which provision of the Constitution constitute basic structure is uncertain and may vary from judge to judge or bench, thus leading to an uncertain democracy. But the courts have been very responsible about applying basic structure doctrine and have not abused their powers. This has led to basic structure doctrine being adopted in international jurisprudence. An example being Bangladesh Supreme Court in 1989, quoting Keshwananda Bharati judgment, applied the basic structure doctrine to Bangladesh Constitution as well. Uganda too referred the Keshwananda Bharati judgment in 2019 to adjudicate the amendment made in the Constitution. Apart from this, the basic law of Germany under Article 79, talking about the amendment procedure, has a provision saying that there are certain provisions in the Constitution that are not amendable, thus codifying the basic structure in the Constitution itself and not through the courts.